All right, so there the prosecution's argument. Now, Lara, you gave him a D. I gave him just a D plus. So we're basically in the same grade range. What about it was just enough for you and not more? What did you think he could have? Do you think he could have been a little bit stronger in his arguments? Maybe get some more evidence out. What did you think?
He was basically mostly relying on the horrific nature of the act, describing the condition the bodies were in and where they were found. But he has to tie it into Chad Daybell. It's great to argue. Yes, I'm not saying it's nothing. The fact that they found the bodies on Chad Daybell's property is pretty damning. But part of what they need to show is his knowledge. I mean, the predicate for all of this is that Chad Daybell had to have known that these kids were killed and buried on his property, in his backyard, or wherever it may be. And I don't think they'd really established that. I don't think they presented enough evidence to tie him into the murders. I think the most maybe that they've done is maybe Alex or Lori, and a lot of the evidence that came in had to do with Lori lying. Lori claiming that the kids were with the grandmother when, in fact, the grandmother had said, "Go find my grandchild." Lori's the one constantly lying to different people, and that was the evidence that came in. It's not necessarily Chad. So, I mean, I have to admit, it was very, very thin ice that they were skating on here. But, again, the court found that there was enough probable cause, and again, that was not a surprise. But that's why I was giving him a D. They really didn't have enough. They barely made it. They could not make a strong connection between Chad and the concealment or the conspiracy, even the overt act. Where were the overt acts? Just because someone's on your property and the bodies are there, you got to make a better connection than that.
Yeah. Now, he's got 17 days. Part of the judge's ruling was that on August 21st at 9 a.m. via Zoom, Chad Daybell will be arraigned, and potentially Lori Daybell, if the same outcome is seen in her preliminary hearing, which is next week. We'll be covering it again on Monday and Tuesday here at the Long Crime Trial Network. Now, there's 14 days for his defense attorney. Is there a potential for the defense attorney to do a writ of habeas or maybe a motion and argue, hey, we reviewed the facts, we reviewed the testimony, and we're not really seeing that overt act, we're not really seeing X, Y, and Z. Could there be a motion down the line to have Chad Daybell released because maybe the defense argues that this decision was done in error?
Definitely. I can see them filing a motion to dismiss first based on the transcripts and the evidence that they came in during the preliminary hearing. If that is denied, then they can go to the next level and file their writ. And I'm sure there's deadlines in the jurisdiction for that. But yes, of course, they can make that argument. Like I said, the evidence was not strong. They had to make a connection between the two. Yes, it's circumstantial. I didn't see really any direct evidence. Most of it, again, like I said, was circumstantial, not very strong evidence, very weak evidence, barely tying Chad Daybell into the alleged crimes. And defense attorneys said it best. Just because they're married and happen to be together is not enough to say he's part of the conspiracy.
I think that every married couple in the country is happily agreeing with you as well, that no one wants to get tied to the actions of their spouse if they're criminal just because they're married. But let's listen to the defense attorney in their arguments, in the closing arguments for that of the preliminary hearing, and see how they kind of made some strong arguments there that obviously didn't work out.
The testimony, according to this prosecuting attorney, is that Mr. Daybell was married to Ms. Vallow. That's doesn't provide anything. Not only doesn't it provide an overt act, it doesn't provide an agreement. Marriage is not an overt act towards a conspiracy, and marriage is not an agreement to conceal or to conspire. In addition, what they have is Mr. Daybell making a comment to a police officer. That is not an overt act to conspire or an agreement to conspire as well. And then what they have an obscure text message that says, I burned some items in the fire pit and I buried a raccoon. Now, they can suggest whatever they want with that, but there's been no indication of any evidence that this act took place on the 9th or the 22nd or 23rd or whatever day it was. And quite honestly, Judge, they don't even come close on the concealment of Tylee. They don't even come close on the concealment of JJ. And the conspiracy, they lack the agreement. And quite honestly, Judge, if this is what the evidence is in terms of an overt act, I would submit to the court that I understand the burden in a preliminary hearing, but they aren't even close on the conspiracy in either suggestion that, in either case, in regards to an overt act plus an agreement. I'm respectfully asking the court to dismiss the charges. They haven't met their burden, and I don't believe they have provided any near the type of evidence that is necessary to even overcome that small threshold. Thank you, Your Honor.
All right, so Lara, he did a pretty good cursory glance of why he believes that there wasn't enough evidence to reach that very low threshold, even though the judge disagreed with him. I guess this is kind of my fear when I do this, and so I'll kind of ask if you feel that happened here. Do you think that if the defense attorney spent more time on his arguments and kind of really flushed out what he was showing, even though I think it was very clear for all of us to see where he was going, that he might have gotten more traction? Or are you just going to be like, all right, the judge kind of knew what he was going to do from day one, and nothing the defense could have said could have changed his mind?
I mean, it's hard to tell, honestly, and it's hard to say things in hindsight. He made the arguments, and he made very strong arguments. Now, in a case like this, where there's been so much public scrutiny and people following it, everybody's interested in what's going to happen in this case. I think it was going to be an uphill battle for the defense attorney, regardless of the length of the argument and how much detail it entailed, to convince the judge not to hold his client to answer. I think the probable cause was going to be found regardless. I'm not saying the judge did it even though there was no probable cause, but I'm telling you, it was a close one. I mean, like I said earlier, the prosecution barely made that threshold, if they even did. And I can see the arguments from defense, I'm sure it's sure to come fairly soon, that this wasn't enough, and they're probably going to ask for a dismissal. Now, is that going to happen? Most likely not. Maybe an appellate court would look at it differently, but at this level, at the trial level, I just don't see it happening.
Yeah, and I think the way for a lot of people to think about it is what we're talking about is just laying the foundation for a possible appeal, about filing the motions, even though they're probably not going to win. And the best example I can probably give you, if you guys are following the news, look at what the court did in the Boston Bombers case of overturning the death sentence just because of something so tiny that was argued in terms of the bias of jury selection. That was something that's probably overseen, but if you can plant these seeds, plant these arguments, even something like the Boston Bombers case where the death penalty is overturned can actually affect a case like this. And so you've got to have a defense attorney who really argues each and every point, no matter how small or how big they are, or how successful you might believe they could be. But we're going to continue with more. We're going to talk more on the Chad Daybell case, the preliminary hearing. He was obviously found probable cause, still being held. But we'll dissect that preliminary hearing a little bit more after this break.